This video was created with AI to support SQE1 study. We are independent and have no affiliation with the SRA, Kaplan, or the SQE. We do not share exam content, and our videos are for informational purposes only and should not be used as legal advice. Please check and refer to primary legal sources and recommended prep guides as you study.
Welcome back to another New to Law Breakdown, where we cover the concepts you need to know for your SQE1 exams. First, a special thank you to all our new subscribers. We truly appreciate your engagement and feedback. If it's your first time here, welcome to our channel, and we hope our content helps you on your way to becoming a Day 1 solicitor. All right, let's just jump right in. Picture this. You've just qualified, your very first client walks through the door, and they've been charged with a criminal offense. The absolute first question you need to answer is, where does this whole process even start? Today, we're going to get to the bottom of that by looking at the Magistrates Court, the Youth Court, and the Crown Court. Trust me, understanding this isn't just theory. It is the bedrock of criminal practice and a massive topic for your SQE1.
So before we can even point to a courthouse, we have to get our heads around a really crucial sorting system. You see, in England and Wales, not all crimes are equal. They're actually funneled into 3 different categories, and the category an offense falls into, well, that basically dictates its entire journey through the justice system.
First up, we have summary offenses. Now, think of these as being on the lower end of the seriousness scale. We're talking about things like a common assault, most driving offenses, or maybe being drunk and disorderly. The absolute golden rule here, the thing you have to remember, is that their path is totally fixed. These cases are always handled from start to finish in the Magistrates Court. That's it. Simple as that.
Okay, now let's swing to the complete opposite end of the spectrum. These are the indictable-only offenses. The name actually gives you a massive clue. An indictment is the formal charging document used in the Crown Court. So, as you can probably guess, these are the most serious offenses you can imagine. We're talking murder, robbery, rape, and just like summary offenses, their path is also locked in, but it leads to a very different place. They have to go up to the Crown Court for a trial with a judge and a jury.
And right in the middle, this is where things get a bit more complicated and honestly a lot more interesting for lawyers. These are the triable either-way offenses. This bucket includes a massive range of crimes, everything from theft to assault occasioning actual bodily harm, or ABH. And just like the name says, they can go either way. They're in this gray area, not automatically serious enough for the Crown Court, but maybe too serious to be stuck in the Magistrates Court. This means there's a special procedure to figure out exactly where the trial is going to happen, and we're going to break that down in just a bit.
Right, let's talk about our first court. And I'm going to say something now that is probably one of the most important things to remember for your SQE exams. Are you ready? Every single criminal case in England and Wales, I don't care if it's a minor speeding ticket or a murder charge, it has its very first hearing in the Magistrates Court. There are absolutely no exceptions to this rule.
So, what exactly is this court? Well, it is the absolute engine room of the criminal justice system. Most of the time, cases are decided by 3 magistrates, who are also called justices of the peace. These are volunteers, lay people from the local community, and they get legal advice from a qualified clerk. Sometimes, though, you'll have a single legally qualified district judge hearing a case. But here's the clincher, and never, ever forget this. There is no jury in a magistrate's court. The best way to think of it is like a giant sorting office. It handles all the summary offenses itself. For those big indictable-only cases, it just does the first bit of admin and sends them straight on up to the Crown Court. And for those tricky either-way cases, it's the place where the vital decision is made on where that trial will eventually be held.
So you've probably heard of the Youth Court, right? It's really important to know that this isn't a completely separate building. It's actually a specialist version of the Magistrates Court. It deals with most of the crimes committed by young people between 10 and 17. The whole vibe is a lot less formal, the magistrates get special training, and there's a bigger focus on rehabilitation. But at its core, it's still operating under the umbrella of the Magistrates Court.
So, after the Magistrates Court has done all its sorting, where do the really serious cases end up? They get sent up to the Crown Court. This is the court you've probably seen on TV. You've got the judges, called circuit judges or recorders, in their wigs and gowns, and of course that crucial jury of 12 ordinary people.
And this comparison just lays it all out perfectly. In the Crown Court, the big decision, guilty or not guilty, that's made by the jury. The judge is there to guide them on the law, and if the jury says guilty, then the judge decides on the sentence. And look at the difference in sentencing powers.
Magistrates can usually only give up to 12 months in prison. The Crown Court, on the other hand, can go all the way up to a life sentence. That huge difference in power is exactly why figuring out which court to use is so important.
Okay, so let's get back to those tricky either-way offenses. How on earth is the decision made? Well, it's a three-step called the allocation procedure. Let's walk through it. First, in step 1, the plea before venue, the defendant says if they're pleading guilty or not guilty. If they plead guilty, the magistrates usually just sentence them then and there. But if they plead not guilty, we move on to step 2. The magistrates hear a summary of the case and ask themselves a critical question. If this person is found guilty, are our sentencing powers enough to deal with them? They need enough info to make that call. If they think it's too serious for them, they have to send it to the Crown Court. But if they say, yep, we can handle this, then we hit the really crucial step 3, the defendant's election. The defendant gets the final say. They can choose to stay and be tried by the magistrates, or they can elect to go to the Crown Court for a trial by judge and jury.
Now, understanding this whole structure isn't just about where the trial is, it's also absolutely fundamental for 2 other really practical things. What do you do if you lose and want to appeal? And who is actually allowed to stand up and speak for your client in these different courts?
Okay, the appeal routes are very specific, and you really need to know this. If your client is convicted in the magistrate's court, the standard appeal is to the Crown Court. It's basically a complete do-over, a full rehearing of the case. But, and this is a really key difference, if the reason for the appeal is that the magistrates made a mistake in the law, that appeal goes somewhere else entirely. It goes to the High Court. This is called an appeal by way of case stated. The famous case Edwards v. Bairstow is a great example of this principle, where it was established that a decision with no evidence to back it up is itself an error of law. And if you're appealing from the Crown Court, well, that goes up to the Court of Appeal, but you have to get their permission first.
So, who gets to do the talking in court? Well, as a solicitor, you automatically have the right to represent your clients in the magistrates and youth courts. Barristers, of course, can appear anywhere. But here's the catch. For a solicitor to stand up and represent a client in the Crown Court, you need an extra qualification. It's called higher rights of audience. A solicitor who gets this becomes a solicitor advocate. So the takeaway is, without those higher rights, a solicitor can only do advocacy in the lower courts.
All right, that was a lot to take in. So how about we put it into practice? It is time for our SQE practice zone. Let's see how you handle a question. You ready?
Okay, have a read of that and take a second to think. So we've got a tribal either way offence, a not guilty plea, and this is the key part. The magistrates have said, yep, we can deal with this. So based on everything we've just talked about, what is the very next thing that happens?
And the correct answer is C. This is a textbook test of that allocation procedure. Remember step 3? As soon as the magistrates say they can keep the case, all the power shifts to the defendant. They get the final choice. Do they want to stay with the magistrates, or do they want to exercise their right to go before a jury in the Crown Court? It's their call.
Let's do one more. So, your client's been convicted of a summary offense in the MAG's court, but look closely at the reason for the appeal. They think there was an error of law. Which court is the right one for that very specific challenge? Think back to those 2 different appeal routes from the magistrate's court.
The answer is B. And this is such an important distinction to get right. If the defendant just thinks the magistrates got the facts wrong or the sentence was a bit harsh, they go to the Crown Court for a complete do-over. But if the argument is that the magistrates got the law wrong, that they misunderstood a legal rule or misapplied it, that is a question of law for the senior judges in the High Court to sort out. Fantastic work on those questions. Right, let's pull all of this together with a quick final recap. Think of this as your SQE checklist. These are the absolute non-negotiables you need to have locked away. Okay, let's fire through it. Every single case starts in the MAG's court. The 3 offense categories, summary, either way, indictable, decide the journey. The Crown Court is for the serious stuff and is the only place you'll see a jury. Remember those 2 distinct appeal routes? Facts go to the Crown Court, law goes to the High Court. And finally, solicitors need those higher rights to speak in the Crown Court.
And before we finish, let's quickly flag the common traps people fall into on this topic. Don't let this be you. The biggest mistake is forgetting that even a murder trial has its very first hearing in the magistrate's court. The second is getting those appeal routes modeled up. And the third is forgetting that the defendant has the final say, that right to elect when the magistrates accept an either-way case. If you can avoid those three pitfalls, you are in a really, really good spot.
Thank you for joining us for another New to Law Breakdown. See you next time.